All right, we are live. And welcome, Daliah, to my channels. I'm so excited to be talking to you.
Thank you for inviting me.
And, as, since we've gotten to know each other, what we've realized is that we don't know very much about each other's practice areas. And I think this is a great opportunity for us to learn about each other. And also, I know that there's going to be a number of people on my channels that are interested in some sort of startup, owning a business, registering trademarks. And I think those are all topics that we can talk about. And so thank you for coming.
Yeah, happy to answer those questions. And likewise, my clients don't know a lot about the technicalities of immigration and potentially foreign investments. So hopefully you can answer some of my questions in the future.
Yeah, sure. So let me just get our introductions out of the way. So
Okay.
I know if you can introduce yourself and tell me a little bit about like how you got started in this area of law, and anything that you think that our viewers would like to know about your background.
Sure. So my name is pronounced Daliah. I'm Daliah Saper. I founded Saper Law over 20 years ago. And the firm is really primarily an IP, media, entertainment, and business law firm. We try to be on the cutting edge of all the cool things, and whether that is currently AI, and back when I first started was social media, and everything in between. So I did start the firm shortly after graduating from law school, and because of that, I had to really find a niche that was evolving because I would have that was my competitive advantage when I started the firm is why would you hire a new grad versus an established firm? And the answer was, I'm the one using the internet. I have a website. I understand now what, social media is and its broader legal implications. And from that, my niche was born. And then as a result, I attracted a lot of web-based businesses, startups. And then I got cases involving, for example, a catfishing case that went all the way to the Illinois Supreme Court. We then worked on revenge porn cases. Then we're currently working on doxing cases, which is pursuant to a statute that was just passed last year. So that's kind of this. But along the way, we also do run-of-the-mill legal work that is relevant to businesses. We start a lot of LLCs and small startups. We trademark. We file trademarks for clients that have multinational offices, and then from the very small mom and pops. So we do manage trademark portfolios, and then we also have clients from everywhere. One of our favorite clients is an Indian company, and they have a apparel brand. I'm sorry, not apparel. They sell apparel, boots, and accessories brand, and we've helped them, for example, get a license with the TV show Yellowstone, so they can do co-brand their bags with the Yellowstone TV show moniker. So anyway, it's a fun practice. Our motto is we need to be cool by association, and therefore our clients are all very creative and interesting businesses or individuals.
That's very exciting. And, thank you for sharing that. So, as you also work with companies, it sounds like it doesn't have to be local. It could be you work with companies from all over the world. Is that?
Yes, that's true. And part of the reason for that is, as IP attorneys, which is the trademark and copyright practice, that you can be in India and want to register your trademark in the United States because that's where you are selling your brand and your products to consumers. And so for that reason, yes, we have an international practice as it relates especially to our trademark clients.
Right. And I think that's so fascinating because that's the same with immigration law. Because it is a federal practice area, we work with clients from all across the globe, basically.
Yeah. And then, you get to be exposed to businesses and clients that you wouldn't otherwise see if you were just a local practice.
Absolutely. Absolutely. And then what that does for my practice area, and I'm sure for yours too, it makes the internet kind of indispensable
Yeah.
as a way to reach clients, connect with them,
Yeah. I'd say a big part of my practice's growth was establishing a very strong online presence in a niche area that a lot of other lawyers aren't focusing on. And so I'd say we get a lot of clients who just happen to be searching for the specific area of law that we practice and find us on the internet.
Perfect. And you know what? So what's interesting is that there is a part of immigration law that intersects with some of the things that you practice, where we have, business owners who also want visas based on their businesses. We have startups that are also visa holders. So there's this, interesting dynamic between how do I make sure that my visa and my business, they don't conflict with each other, and they kind of, grow, without hiccups, essentially. So it's definitely, there's a large population that I think needs both services.
Yeah.
And it's very important for those services to kind of be in sync with each other, if that makes sense,
Well, we always tell clients, hey, you need a good accountant. And if you, or in your case, like an immigration attorney, because lawyers don't know everything. And we actually are highly, I wouldn't say specialized, but we are really focused on our practice areas. And sometimes clients will say, is it okay if I have, 3 lawyers or 2 lawyers? And I'm like, yes.
Yeah.
Trademark lawyer, you can have your lawyer. I don't do divorce law. So sometimes that's a novel concept because they think, oh, okay, I thought attorneys do all the things.
Right.
And you have some general practice lawyers, but you don't want those. You want lawyers who are really doing their particular area of law and are good at their particular area of law.
Exactly. And we only do immigration law for that same reason, is we want to get deep into our practice area rather than just, superficially know a little bit.
Exactly.
Right. So meeting other focused professionals like yourselves, I think, and networking is crucial, because obviously our clients are going to need various services.
Exactly.
So I'm going to dig right into some of the questions that I had for you.
Okay.
But I'm really interested to know, what are some mistakes that you see early on, early stage founders make?
Oh, okay. Well, it's a mistake that lots of businesses make, not just IP mistakes. The big one is you get excited, you want to go into business with a friend, you start doing the things, and especially in a business that is software related or content creation focused, they just start doing it. And they're like, well, it's my best friend, or it's, whatever. It's an extended family member. It's going to be fine. And inevitably will not be fine. There's always, and I say you approach the business with a partner like you would approach a marriage. Although you have high intentions and all the best of hopes, the reality is that not every marriage makes it, and certainly a lot of business partnerships don't make it. So sure. IP is particularly important because in the absence of a really carefully drafted agreement, you might be in a position where you either don't own the work that you developed or you co-own the work that you developed. And in for example, if I write software code with another person, that person decides they want to license it to, a political party I don't agree with, or any sort of organization I don't like. I cannot stop them from licensing it because they also own the whole work.
Right.
You're in a situation where, like, well, how can he do that? Doesn't he need my permission? No, he does not need your permission. He does not account to you for whatever he makes. And so those are the nuances that a lot of business owners don't understand before they get started, and they come to me after the fact, and now we have to fix it. But sometimes you can't. So I would say is entering into relationships without fully putting on paper what the terms of that relationship should be and is intended to be.
Right.
The other one I can mention is it's not so much as a partnership problem, but they might launch a brand and not do their due diligence before they invest a lot of time, energy, and money into developing and promoting that brand. Because then they'll call me and say, we just got a cease and desist letter from a company that claims they have priority, meaning they have prior rights to certain name, and that we need to stop using that trademark, that name. And then we'll say, well, let me look at it. And yeah, go ahead.
Yeah, so it sounds like, when business owners are, obviously they're going to be very excited about their product that they want to launch, or their idea, but they kind of need to take a step back and first make sure that they're protected.
Correct. And so you don't want to, you really just slow down. A little bit of investment in these things in the beginning will save you a lot of headache and money later on. So I usually say, have a checklist. First and foremost, do you have an agreement with your partner?
Mm-hmm.
What is that going to look like? Second, do you have your accounting and other, in your case, if there's immigration aspects and visas and things like that, have you talked to the right other professionals to make sure this will be a successful partnership? And then we look at who are you using to advance these goals? Do you have third-party W-9 kind of contractors, or do these W-2 employees? That has IP implications. What are you using to develop whatever it is you're bringing to market? You need to do clearances on those prior existing works.
Mm-hmm.
So, you want to build a relationship with the attorney because they're going to grow with you and your firm. It's not a legal.
Know you and your business more intimately over time.
Correct. And so we also fix a lot of legal Zoom kind of, I wouldn't call them mistakes, but filings that are more formulaic, and they're like, well, why did they do this way? And I'm like, well, you had a form filler complete it, versus really understanding how to craft whatever it is you're selling and putting that in the appropriate spots in those trademark applications.
Sure. And taking a step back, we talked about, IP and trademarks and all of that, but what really is a trademark and copyright, and does registering either of these, does that help the startup's valuation?
Okay, that's a great question, Dhenu, because we get people who call and they use the words interchangeably.
Mm-hmm.
I want to patent my trademark, and then I want to copyright the and I'm like, whoa. They're all under the same umbrella. So you're right to call a trademark, a copyright, and patent intellectual property. Mm-hmm. But these are three different federal laws that provide protection for an intangible asset. So in English and non-legal speak, they are all property, intellectual property, but they are for different types of things. So a trademark is really about the source of that product or service. So it functions as a source identifier. Am I buying a white t-shirt that says Hanes, or am I buying a white t-shirt that says Armani? And simply by looking at the tag, I as a consumer will know what one brand means and what the other one doesn't mean, and vice versa. And so I will make a purchasing decision based on that brand and what it, what it stands for.
Mm.
So, and a lot of things can function as a trademark. It's not just, the words. It can be obviously a logo, but it can also be the packaging. So trade dress refers to that. If I say my husband came home with a turquoise blue box, people know that's probably a Tiffany's, jewelry box, because they've spent a lot of energy and time into branding the Tiffany blue color, right? Mm-hmm. Then there's a sound can be trademarked. A scent can be trademarked. So a lot of things can function as a trademark, and you would want to ensure that whatever you're using to sell your product or service, you're registering on a federal level so that you prevent someone else from a state that you haven't been in from selling the same type of product, confusing consumers, and diluting your brand equity. So that's the trademark.
Okay.
And then on the copyright end, that's more about what you've developed. So business owners might have website content. Mm-hmm. They might have marketing collateral. They might have certain videos or Instagram posts, or again, content that they've created, and that is subject to copyright protection. And copyrights.
Logo. Is a logo a trademark or a copyright?
It can be both. So to the extent the logo has artistic elements, then you would protect the creative part of it with a copyright. Mm-hmm. You would get a trademark in the logo to prevent someone from selling a service that uses your logo and looks the same. So trademarks are really all about consumer confusion, and copyright's more about protecting the creator's innovation and that creative work. Patents are their own bucket. I'm not a patent lawyer. Speaking about lawyers who do things and don't, a patent lawyer is a specialized field because you need to know the recipe for the invention in order to get a patent. You can't just say, I have an idea for a flying car. I want to patent the idea for a flying car. Mm-hmm. In order to get a patent, which gives you a monopoly over that idea, you have to write out the instruction manual for that plane in order to get the patent. And
Right.
patents it has to be something that's really novel and not obvious to someone who's skilled in, aeronautics, right? If it was a flying plane. So with patents are usually difficult to get. They also rely on, you do a prior art search to make sure you're not trying to patent something that's already existing, or that you're not infringing on an existing patent. And if you're successful in getting a patent, you're basically protecting an idea. Copyrights don't protect the idea. They protect just the physical way you've reduced that idea to writing and you've presented it.
Production of it, or
yeah. So like this speech, if you actually own the copyright to this recording, even though I'm speaking, I didn't put what I'm saying on paper or anything before I've spoken to you. So people are surprised to hear that too. Like, well, I'm the one speaking. Why do you own the copyright to this podcast that we're recording right now?
Right. That's interesting.
And this is kind of the topics that might come up. Well, I was doing this podcast with her. It was a joint initiative.
Mm-hmm.
Agreement. No. So this would be an example where we're not, because Demo, I recognize this is your platform. But this is an example where people don't come in, don't write it. They do it on a handshake. They show up, and let's say I turn around and be like, actually, this podcast episode goes viral and you make $1 million, talking about the difference between trademark and copyrights. Demo, I want $1 million. And you'll be like, what are you talking about? I invited you on mine. I'm the one recording it.
Right.
And then we fight about who owns this output. So, so that, again, that's copyright. And then the branding, like I said, I don't know. There's no real trademarks unless the series is branded with a particular name.
Got it. Interesting. So that is, I think I like that example too, because it puts it very much front and center. Sure.
Yeah. And the second question is, can registering either increase a startup's valuation? Absolutely. Right. If anyone's ever watched a Shark Tank episode, what's one of the main questions the investors ask, right? The sharks. Is this patented?
Is
this trademark? How do I know someone's not going to go do the exact same thing? I have a trademark on this fun name. I have a copyright on all these, materials that I've developed. And without those, you're really opening yourself up to really much broader competition. And you don't want that. So a startup oftentimes, evaluation oftentimes really has a separate line item for the goodwill and the brand equity that is the trademark or the other IP assets.
Sure. So it's worth it to go through the legal paperwork, even if it kind of slows down the production and the starting of somebody's business.
Yeah, and it doesn't really even have to slow things down. I would say it's just part of your due diligence. Like, why spend so much money on something that you may have to change? So it's just part of the pre-startup process to do all your homework is to get all this stuff in order.
So in the long term, it's actually probably more efficient.
Oh, 100%. You will spend less money later if you get all this stuff figured out at the beginning.
So you actually answered this next question of mine already.
Actually, I can answer this further. So the name of an entity doesn't mean you have a trademark. If I'm XYZ LLC, I may be XYZ LLC and I own ABC trademark, or like Daliah flowers are fun trademark. So sometimes they're the same, but doesn't mean that they are always the same. So owning a trademark is the name that you are using to sell whatever it is you're selling that is consumer facing. An LLC name is just the business name. It could be the same, but it could be totally different too.
So just registering the LLC is oftentimes not enough to really protect that.
No, not at all. Now, if you are using the LLC to be if it's the same name, right? Like if I'm Saper Law and I'm Saper Law LLC, then yeah, they're one and the same. But if I am Saper Law LLC, but I'm really doing business as Startup Law is Fun, then my trademark is really Startup Law is Fun. It's not the law firm brand name, because that's not what people really engage with.
Right. And oftentimes it's also just about making sure that others are notified of your rights.
Correct. Now, there is a difference between a registered brand and a common law brand. Right. And that's why you might, now after this, you'll know, if you see the TM sign, it means it's not registered. That means your rights are. Right. Yeah. So TM just means I woke up and I started selling something. So and I tell this to clients, like, I can put a TM on my stuff right now. Yes. You don't need to do anything special to put a TM. You're just telling people this is a trademark, and I'm developing my brand. And then if you put a TM and you don't go the federal registration route, your rights in that brand are only as good as where you actually sell your products or services. So if I'm a local Chicago brand and I have no sales to California, well, then someone could theoretically start the same kind of company with the same name, and I could not stop them. So the only way to really get that nationwide protection is to go through the federal trademark registration process.
Sure. Okay. So that's good. And so another step that a lot of investors, especially, startups and tech startups and major startups have is they need investors, right?
Mhm.
So what do you see are some maybe red flags when bringing on investors, or what are some things that people can do to protect themselves when they are bringing in outside funding?
Well, like I said, contracts. What is the expectation of the investor? Are they going to be passive investors? Are they going to be active investors? What are they going to be giving you in exchange for the equity that they are acquiring? What are the provisions in the event of a sale of the business? How much equity do you keep? Are there anti-dilution provisions in the event that there are additional investors that come in? There's drag along and tag along rights. There's no one size fits all answers here. I think it really depends on what you need that investor to do. Are they really just a source of capital, or are they here to be more of an advisory position, or are they actually helping you run the business? What is their exact role? Red flags would be, there's sometimes you just don't know what the red flags are. That's why you need the operating agreement to lay out the prenup and all potential contingencies of when a red flag might arise that may not have been apparent at the time that the transaction was entered into, that the investment was accepted.
So really, even for bringing on investors, it's important to have a lawyer kind of, make sure to vet all of that paperwork.
Yeah, I would also say people are so quick to give away equity in the beginning. They're like, I don't have any money, so I'm just going to give him 10% of the business so that he makes my logo. I'm like, what? You don't need to give away 10% for a logo. Go get it on, Fiverr, and then you call it a day. So I think another mistake that sometimes startups do is they're so quick. They don't have money, so they think that they should just give away the business in equity in exchange. And I usually try to dissuade people from doing that. Avoid investors, because the more cooks in the kitchen, inevitably the more disputes.
Sure. Yeah, because then at some point they start having more of a say.
Correct. Yeah.
Right.
Or you're accountable to them, right? So you have to make sure that you're making decisions that aren't going to make your investors mad.
Makes sense. And then here, in the case of someone developing something at work, right? Or maybe on the side, but related to their area of work, or what is that line? When does the employer own the rights?
Yeah.
The creator own it?
This is a great question, and it does come up all the time. We advise clients who are about to accept a position, and also business owners who are concerned about employees leaving. So there's, under at least the Copyright Act, which is really the one you want to look at, is there's a work for hire provision in the Copyright Act that says the work created by an employee within the scope of their employment is automatically owned by the employer. So if my day job is to be a software developer for a children's video game, and at nighttime I'm like, okay, well, I know how to make kids video games. I'm going to make my own. That's not the one that the company asked me to make. You're probably going to be out of luck, because your job is to make kids video games. And just because you're making one that's not one that the company asked you to make doesn't get you outside of that kind of the two-pronged test. Are you an employee? Was it within the scope of your employment? So in that scenario, the employer would automatically own it. The employee should not do that work until they get an explicit written carve out. On the other hand, if I'm a photographer, and I give this example a lot, people really don't understand this. I hire a photographer to come take photos of me for headshots for the law firm. The photographer charges me $1 million. Let's use a crazy dollar amount. I pay the $1 million.
Sure.
Do I own the copyright to those headshots?
Do you? I don't know.
What would you think? I just paid for it.
Yeah, absolutely. I think you should.
The answer is photographer retains the copyright to those photos.
Oh.
The photographer is not my employee. He's in contract. And
Okay.
so you have to get an agreement in writing that assigns all of those rights to you. Otherwise, you just have an implied license to use it for your website.
Got it.
Lawsuits come around when the photographer's like, yeah, if I knew you were going to put it on billboards, I would have charged you $2 million. You
Sure.
only for it to be on your website. So you don't want that ambiguity, especially if the person is not your direct employee.
Got it.
Again, so the employer will own the right to content produced by the employee that is within the scope of their employment. Now, again, an example would be if at nighttime I'm writing a book, about, whatever, apples, that has nothing to do with my company, day job, they can't own the book.
Right. Okay.
But the tricky thing is like the software example where, developers tend to be making code and they have lots of projects, and it's like, well, is this code too close to what I code during the day? Will they try to claw that into their IP clause of what they own, claw back that? And so we will negotiate those things on behalf of the employee.
Well, I have a crazy example, and I was wondering what you would think about this one. So suppose if someone is working as a photographer full-time for a photography company.
Yeah.
And then when they go home, they take a bunch of really nice photographs of their family.
Mm-hmm.
Can the company now claim copyright to their family photographs?
Right. So you would argue, yes, I'm a photographer, but not a photographer of all things. And it's not my job to, like I said, the example would be, it's not my job to take family portraits. I'm a commercial photographer and you send me out to take photos, I don't know, of food. Mm-hmm. But his job is to be a family photographer and he takes the photos of his family at home. Yeah, arguably, he doesn't own this.
But there needs to be like the level of awareness. And this to me is actually surprising, right? Yeah. So the level of awareness just needs to be a lot greater when it comes to these types of issues, because there is a lot of gray, it sounds like.
Yeah, well, what happens more practically, the people are like, well, I worked on this at work. It's mine. I want to be able to use it in my portfolio.
Sure.
Like that isn't even allowed. You don't have the right to put it in your portfolio, technically.
That's mind-blowing.
Like
yeah.
Practically, is the company going to come after you for something like that? Depends on the company. But, you kind of practically, is your photography going to company care that you're taking pictures of your family? No.
Yes.
But they could. And so you need to assess that on a case-by-case basis.
Sure. Yeah. I think this is actually very illuminating for me as well. So I'm going to have to look up all of my trademarks.
And just like I said, don't assume, just have some, and they don't have to be long, detailed contracts. I tell people sometimes an email is sufficient. I'm like, hey, thanks for coming to take photos. Like, we agree that I'll be the copyright owner of them, right? Yes. That's sometimes all you need. Just a very simple confirmation. So long as
there is a mutual understanding. But I do think that there are a lot of people who, they're in a full-time job, but they have aspirations to someday develop their own products or, their own thing. And if they really want to do that on the side, it sounds like they have to be very mindful of what it belongs to them and what doesn't.
Absolutely. Yes. Any employee who's in the business of creating content as part of their day job should have a discussion with a lawyer before they sign that employment agreement.
Okay. That sounds really interesting. Now, what if someone is responsible for, say, creating content for multiple clients or customers, like maybe an SEO firm or a blog writing firm? Can they use the same blog that they use for one firm for another one? Is that okay? Because they own it, right?
Great question. What typically happens is a company will hire an SEO company, and in their contract, they will have that work for hire provision. I'm hiring you, SEO company, to create content for me, just like the photographer example. As a condition of me hiring you and paying you, you agree that I will own that blog content. So no, you can't use it for another client.
But it needs to be specified.
Yes, and otherwise the company will say, hey, you don't own this stuff. You're just paying us to host it, or we're going to do it, but nothing here prevents us from reusing our templates and our materials for multiple clients. And that's part of what I do every day, is review those provisions and argue about the scope of what they keep versus what the client's commissioning and the client keeps.
Right. And this is very, very meaningful, especially as a company starts increasing their valuation or wants to.
So just because, again, the misunderstanding is that because I spent a lot of money, it's mine.
Right.
And unfortunately, that is not the law.
And I think that is a really, really good takeaway from this whole conversation, if there is one.
Yes.
Right.
Yes.
So just because you've hired somebody, you've spent a lot of money, is not enough. Like, you have to actually make sure you are aware of your.
Yeah, I mean, I want to go back to the photography example. Think about, wedding photographers. You pay them to be at the wedding, you pay them to take pictures of you, but then they give you a portfolio, an album, and you have to buy specific images because they maintain the copyright to those images.
Yes, great example. That's so true. So yeah, I mean, I think that this has actually taught me a good bit, and really made me reflect a little bit on, some of the things that I think we just use in very regular life and don't really think about, and stop and think about, okay, how does this transaction, who owns this product, who owns this image? So that's very, very interesting. And I think the way that this really plays into, so there are, for example, there are visas that are for business owners.
Yes.
And they're having a business a lot of times in another country, and they're wanting to create a business in the US. And so, a lot of times some of these laws may even differ from country to country, right?
Absolutely. Yeah.
So being aware of these things before coming into the US market, I think, is really important.
Especially with like trademarks, for example. We have lawyers that we work with from all different countries, and some countries are first to file, some are first to use. And you need to make sure that if you have overseas distributors, that you have in your contracts provisions that say you can't go file because you're my distributor. You can't go sabotage our brand because you happen to be boots on the ground in that country and we're not in there yet. So,
is there a way to get like a trademark that's international?
There is no international trademark. Each country has its own, but there is a treaty that allows you to have a home country and then expedite filing with one application. But if there's issues with that filing, you would still need to get an attorney in India or whatever the country might be to further prosecute that mark in that country.
Sure. So if someone has a business and it's trademarked and copyrighted and whatever in another country, and they are wanting to open up a branch in the US, they have to kind of do all of that stuff again.
Yes. Okay. Typically. Yes. Especially with trademarks. If you haven't sold in the US, you don't get to assert any rights in the US.
Sure.
But then that's come up with disputes with distributors. So we've had clients, they're a Mexican company, and a distributor went rogue and then created a counterfeit mole sauce and put our client's brand on it, and then try to sell it as his own in other countries. And we're like, wait, so we had to sue that distributor and get them to stop. But so you have to really trust the downstream users, who you hire to be your distributors, and ensure that they are going to follow the contractual terms. And I also say, look, anytime you get overseas, the contract's great, but practically you need to know that the person you're doing business with is going to be trustworthy, because it's going to be very difficult to enforce any contract in a different country.
And I think also in the world of social media, we don't own the content that's on our social media. Am I right?
No, you are not right.
Oh, okay.
You do retain your ownership. And that's partly, think about it. You can post to Instagram and also post to YouTube.
Got you.
Those are two different companies, right? What you do give up when you post is you don't really give up, but what you grant is a very broad license to these platforms to display and utilize and, make copies of your content on that platform. So you're letting them use it and show it without any money, but they don't own your work just because you uploaded it to the platform.
So you can take it down and they can't stop you from taking it down?
Unless there's a contractual provision in that platform, yes.
Right. Okay. Interesting.
Unless
And
it's in the terms of use. By uploading, you understand that you can never remove it from our platform again. Then that's not a copyright issue. That's just like that's the terms of the contract that
that's
you
a
signed.
contractual issue.
Yeah.
Right. Okay. So I think that's interesting too, because sometimes it feels like the social media companies have so much power over how they, you know, display, manipulate, show, whom they push your content out to, you know. But that's the licensing agreement. That's
Basically,
the ownership.
correct. Exactly.
Got
And I mean, if we're talking about that, we can also transition to discussing best practices in marketing your product.
yeah.
We haven't even touched on right of publicity issues. So we talked about trademark copyright. What we haven't talked about is defamation and right of publicity.
Mm.
And so most businesses are now relying on influencer marketing. And as a social media law firm, we are heavily negotiating these kinds of agreements between content creators and brands. Instagram handles that have millions of followers, which translates to millions of dollars in brand endorsements.
Sure.
We also see brands being like, oh my goodness, I saw Kim Kardashian wearing my bracelet. I didn't
Mm.
send that to her, but how cool. I'm going to put a picture of Kim Kardashian wearing my bracelet. What's
Mhm.
wrong with that?
Mhm.
So you will get a letter from her people that says, whoa, wait, I didn't agree to be a brand endorser. Yeah, I may be wearing your bracelet, but I didn't agree to let you use my image to sell the product. Nor do you own the photo that I posted of me wearing that bracelet. So you get hit two ways. So there's this misunderstanding that just because I sourced it on Instagram, and isn't that what people do is you repost and reshare, you can get into trouble for that. Just because it's readily shareable does not mean that will, especially if you're a business, that you will not be targeted with a copyright cease and desist or a right of publicity misappropriation claim.
Wow. Yeah, that's very interesting. So, for people who are wanting to be in the media, and this all then becomes extremely relevant as to, because once you become a public figure or you become more and more known, then what you use and what you show may all they all want to capitalize on it, right?
Yeah, so you actually don't even have to be famous to be able to assert. We had a college student call and say Amazon took my picture. There's an Amazon retailer that took a photo of me wearing this jersey that I bought on Amazon, but they saw the picture and then they put it as one of their sample pictures of people wearing the clothes. She's like, I don't want to be on the page, especially for free. So you don't even have to be famous. I mean, you just get a right, and different states have different scopes of protection for your name, image, and likeness. But as a business owner, you should always get permission, even if it's a simple DM. Hey, love this photo of you doing XYZ. Do you mind if we use it on our page?
What about when it comes to kids? So kids can't legally give permission, right?
Yes. So you're going to have to be extra careful with children. You have to get parental sign off. There's additional different states have different rules about disavowing contracts after they turn 18, and if they don't affirmatively do it, or if they continue to act as if the contract's in place, then the contract is valid. But best practice is to get parental write-off before you display any image of a child.
Right. I know that for my kids' schools, for example, sometimes we have to sign waivers to allow them to take pictures and all that.
Yeah, again, best practice. You don't always have to. If I'm just out and you're in the public and I take a picture of people on the streets, it's an art piece and not a commercial use. You're going to have a hard time stopping that kind of an image from being distributed.
Sure. Like at a birthday party, a bunch of people taking pictures, and most for personal use, it's okay.
Exactly.
Okay, so how the product is being used also changes.
Yeah, so for the name, image, and likeness, it's really whether or not you're using it for commercial purpose, and that's usually to sell something, right?
Right. Yeah, it's good. I mean, you've given me so many things already that I've learned. So, anything else you want our viewers to know about?
I just be hyper vigilant with your brand. Put a Google alerts. There's a lot of ways to sabotage online. So we didn't touch on defamation and negative reviews. We do a lot of addressing bad reviews online, whether they are defamatory or just disparaging. There's a legal difference.
Mm-hmm.
Protecting your brand.
How do you, I guess, yeah, let's touch on that a little bit, because how do you then, if somebody's written in a negative review, say, for example, say, you have a client,
Mm-hmm.
and the client had a good experience with you, but the client's spouse or the client's mom or somebody else doesn't like you for whatever reason, and they leave a bad review, but it's not your client. Is that,
I actually litigated a case involving a lawyer suing a bunch of people who are upset with the things the lawyer said, and went on his Google page and put 1-star reviews on his business page.
Mm-hmm.
The court found that there's free speech protections. So the real question is, what is being said? If I say I think Bob the lawyer is the ugliest human being on this planet, and he's a jerk,
Mm-hmm.
1 star, that's not actionable, because opinion is protected by the First Amendment, and that's not defamation. Defamation is Bob the lawyer is stealing my client money to buy yachts. Right? So if you're making a factual, demonstrably false statement about someone, that's actionable. That would be defamation. And so that's the first thing we look at. Is it just someone who's had a bad experience and says, I think their customer service is bad? Or is it they're saying the food is poisoned and I saw, rats and cockroaches in the restaurant? So, and again, you also have to act fast with defamation. If you decide to ignore it and then it becomes a problem 2 years later because Google's algorithm changes and now it's the first search result, that too late. There's a 1-year statute of limitations in Illinois to take action. And sometimes it's not worth it to file a lawsuit. We say, look, is this something you really need to spend money on litigating, or just put in a response and just do better with your PR and get better reviews to push down the negative review? So it just depends on how severe the statement is and what the statement is, and in context, how damaging it really is.
Right. And then also, I'm guessing, how much you can prove that that statement is not true.
Right. And because truth is also an absolute defense. And so we get a lot of calls, sexual assault cases are really hard, right? If you've accused me of sexual assault and the person says it's true, he did or she did, prove or disprove whether that took place. That becomes very difficult. It's going to have to be relying on someone's testimony and who the jury or judge finds more credible.
Right. So in some cases, do you find that for fighting a defamation case, does it in some cases, does it have a negative effect?
Yeah, negative in the sense that you're making public allegations you wouldn't otherwise want to amplify.
Right.
Negative in the sense that it can be very invasive. You're exposing yourself to discovery and depositions that you will have to sit through, and you might get a negative outcome, especially with an accusation that's difficult to prove or disprove.
Right. And then it's even more known and more public. So you have to be very careful before bringing one.
Correct. So it just depends on how severe the allegation is, or how absolutely fabricated we had a plastic surgeon who was accused of killing his patients and doing cocaine. And we sued, and that was promptly removed because it was a totally baseless accusation. So that's one where he was like, this is outrageous and I will sue because it's unacceptable that those statements be made about me as a professional doctor.
Sure. Okay. Yeah. No, this is all, I think, very, very interesting. And I think in some ways relates to all of us, right?
Right. These are things everyone was afraid of a bad review. Everyone uses social media. All businesses are online in some capacity. So yeah, touches on a lot of things.
So Daliah, if someone wants to retain your services, how can they reach out to you?
You can find me on all the socials, but obviously the website's the most direct way. My website is Saper Law. I don't know if it's backwards or not on the screen, but it's my last name, law.com, saperlaw.com.
Okay. So they can contact you via your website, and all of your other contact information will be found there as well. And then you have social media, so if they even search your name, they should be able to find you.
Yes, exactly.
Okay, great. Well, thank you so much for your time and for educating my audiences on so many interesting things. If anyone, as you said, I mean, just to remind everyone, you work with people all over the world. So it doesn't have to be, we're both here in Chicago, but it does not have to be in
No.
Chicago. Hopefully if this causes someone to take a pause and reflect and decide, hey, there are areas where I could be a little bit more careful, they should reach out to you, right, and explore that.
Yeah, that'd be great. It's easy to book a consult with us, and we try to be very accessible. That's kind of our motto.
Right. And then similarly, if any of you are grappling with immigration and IP or startup issues, business issues, you do need an immigration lawyer as well. And our website is SwagatUSA.com. My name is Dhenu Maru. This is Daliah Saper, and we are so, so, so glad to have this conversation. And hopefully people get something out of it. And I definitely think that they will, because I did.
Yeah. Sounds great. Thanks for having me on the show.